Mr. Sadow's here. I wonder, Mr. Sadow, would you like to weigh in and talk about some of the thought process behind the opposition?
Well, the opposition at this point is fairly simple. My client has a trial date in D.C. in March. He has a trial date in Florida, Southern District of Florida, in May. The New York case, which kind of was the first one brought, if I remember correctly, is awaiting a new date. But it's, I think, going to follow the case in Florida. And depending on the length of cases, I don't see how any way this court could be set for trial in August. And of course, while the state doesn't give it any consideration whatsoever, it's very possible at that time that my client will be running for election for President of the United States for the Republican Party. And that's somewhat prescient, I might think. And I know that the preference would be that he would not be on trial during the time he was campaigning. I think we'd better leave that to see what happens in the other two cases. And we'll go more into detail on that as we get closer in time. And of course, we have matters that could potentially be considered by Your Honor that might go up on a certificate of immediate review. Again, the court's discretion, which could postpone things. So,
right, and obviously recognizing as a caveat that this is assuming the indictment goes forward and based on the arguments of counsel. But I want to make sure I'm quite clear on the position. So the first level would be we don't think a August or later time frame is going to work because just a conflict. There's going to be another trial going on at that same time.
correct.
All right. And as a backup, if your client is the nominee, put the case that if he is not, is that no longer at issue? If he was not on trial and he was not the nominee, would there be any hesitation?
If anything changes, if by some strange occurrence he is not the nominee, although of course everyone recognizes he's far ahead in the polls to be the Republican nominee for president. But assuming, and I think that's a very low assumption, that he is not, then I think it changes perspective across the board.
And so your request at this point would be that is something that we should at least defer before wading into for a few months.
I believe that that's an accurate assessment of our position. I would point out, I realize the state believes it has an interest here, and obviously we believe that First Amendment rights and other rights. We haven't even brought the presidential immunity motion, which is going to be brought before January the 8th, which I'm suggesting, at the very least, depending on the court's ruling, would go up from one side or the other. Should the certificate of immediate review be issued by Your Honor, and the Court of Appeals of the Supreme Court of Georgia take it up. But can you imagine the notion of the Republican nominee for president not being able to campaign for the presidency because he is in some form or fashion in a courtroom defending himself? I mean, with all due respect to everybody, and I know what the court is attempting to do is to give justice and due process, and I've said that and I'll continue to say that. That would be the most effective election interference of the history of the United States. And I don't think anybody wants to be in that position. I would hope the state would understand that if the Republicans believe he should be the nominee, that he should be given the same fair chance to campaign in national politics as the Democratic nominee, which at this point appears to be President Biden. So I hear what the court is saying, and so the bottom line right now is I don't think we should set a trial date and see how things materialize and kind of take it step by step.
And to further clarify, would it also be your client's position that he would like to be present for every day of a trial that occurs?
That would be presumptive, I think, on my point to say. There are certainly, he would want to be present for matters involving jury selection and then into the trial itself, because we talk here about jury selection potentially taking a number of weeks or potentially months. But I can't speak for President Trump on that at this moment. I need to have more interaction with him and his campaign team and a lot of other people that come into play in making such a decision.
Okay. Mr. Wade, anything you want to weigh in on in reaction? And also, I don't want to leave other co-counsel out of this if they have something they want to add.
Yes, sir. Just respectfully.
Actually, let me do that first. So you get to respond to everything in bulk. Was there anything else that co-counsel wanted to add in on this, to the ones that are here today?
The only thing I wonder is if at some point you're going to talk about severance, and that could change the dynamic as well. Regardless of the state saying they don't want anybody severed, you've indicated in the past that you thought it would be a severance, and that could affect who goes to trial when.
Yeah. No, there are a lot of moving parts, and I don't mind kind of saying where I am initially and soliciting input. But I'd cut Mr. Wade off. So, Mr. Wade, anything in reaction that you wanted to add?
Yes, sir. Just respectfully, the district attorney has made it clear that she has no interest in interfering or getting involved with this presidential election. Her sole focus is to move this case forward and not with respect to anything that's going on outside of Fulton County, Georgia. Now, having said that, let me say this. Has the court closed the door on possibly entertaining an order that would contemplate both circumstances in case the case does not move. The other case that the court is believing is going to go forward that would impede our ability to move forward with an August trial date. What if that doesn't happen? So could the court fashion an order saying that if it doesn't happen, then August it is?
Well, I'm wondering how we can square that. So you're saying that the state's position is that this case should not be interfering with an election. Mr. Sadow's position is that by going forward, starting in August, it would last, an estimate initially was 5 months. That was just with two co-defendants. That takes you through 2025.
I think it was
right?
4 months.
Right. Well, I'm adding in our buffer and the defense case. I would presume they might want to present some evidence, right? What would be the state's response that having this trial on election day is election interference?
This trial does not constitute election interference. Let's be clear. This is not election interference. This is moving forward with the business of Fulton County. I don't think that it in any way impedes Defendant Trump's ability to campaign or do whatever he needs to do in order to seek office.